So today I wanted to talk about the legislative privilege in the state of California. What is a legislative privilege and how is it applied here in California? And is it the same or something different than legislative immunity? So there's been a longstanding doctrine at both the federal and state levels called legislative immunity. And basically it means that legislators are generally immune from civil liability for their official acts. On the other hand, a doctrine called legislative privilege creates an evidentiary privilege against giving evidence about official legislative acts. So in essence, the legislative privilege allows an elected member of a legislative body to speak freely in debate without any sort of legal fear that the legislator will be sued for what he or she says, such as for slander. The term sometimes is referred to as a parliamentary privilege because it originated in European parliaments, particularly in Britain. So again, to distinguish the two, legislative privilege versus legislative immunity, the legislative immunity basically protects a legislator from a civil lawsuit in cases of either a legislative act or the legislator's individual motivation for that legislative act. And again, on the other hand, legislative privilege is a privilege for evidentiary purposes that limits the type of evidence and testimony that can be brought forth in a civil trial. Now, you might ask yourself, why would these elected officials have this legislative privilege? And basically, historically, the privilege has been meant to ensure that verbal or written statements made by legislators as part of conducting themselves in the legislative business is intended to provide these elected officials with the ability to engage in a robust debate, obviously to consider different points of view. And so it's the courts that refer to this as the legislative privilege. And it is actually codified in California statute. It is section 47 of the California Civil Code, which is a pretty lengthy section of law that provides a number of things. And there's also two additional sections, 47 and 48, dealing with the legislative privilege as well, that you should take a look at if this topic is of interest. The courts here in California have basically interpreted Civil Code Section 47B as an absolute privilege, which basically means that officials are immune from civil lawsuits for making certain statements as part of the official proceedings. And this has been upheld in court decisions as recently as 1994. Section 47B1 protects statements that are made in, quote, proceedings of all legislative bodies, whether state or municipal. So it's not just California state legislators, members of the state Senate and state assembly, but it also applies to local elected officials, such as members of the Board of Supervisors or city council members. This has also raised a question about, does the legislative privilege apply to non-legislators? And at least here in the state of California, the answer to that question, perhaps surprisingly, is yes. So the courts in California have applied the legislative privilege to official legislative proceedings and, for example, have applied it to a witness's potentially defamatory testimony before a local government committee concerning a proposed ordinance that local government is about to adopt. There's also a case specifically holding that the legislative privilege may extend in certain circumstances to non-legislators. That was in 1995 in the case of Board of Supervisors versus Superior Court, a California appellate court decision. And one of the main cases is the appellate court decision in Rizzo, R-I-Z-Z-O. And there the Court of Appeal said that the legislative privilege is, quote, broad and comprehensive, and that the privilege has to be, quote, construed broadly. And so as a result, the California courts have generally looked at whether the statement made is connected to the official proceeding and whether that statement serves a useful function in that particular official proceeding. There was a case called Winograd, Winograd, where the California court ruled that the plaintiff's statements to the press about a public proceeding, a city council hearing here, fell within the broad construction of the legislative privilege because the court ruled that the plaintiff's statements were meant to solicit public support for a petition to try and force the city of Santa Monica to end their pony ride and petting zoo. So, interesting case there. Civil Code Section 47B1, as they found in the Rizzo case in the Court of Appeal. Again, it applies to legislative bodies, whether state or municipal. And again, the statement has to bear some connection to the work of the legislative body. So legislative immunity that we talked about at the beginning applies clearly to legislators. However, the legislative privilege doctrine can apply to both legislators and non-legislators alike, including individuals, for example, who testify in a legislative committee, perhaps in support or even opposition to a bill.